Good morning, everyone. I hereby convene and welcome everyone to this public hearing of the Government Administration and Elections Committee. And we have a number of bills for review today. My co-chair has no remarks from the rankings. So we will get started with our first witness of the day, the Distinguished Treasurer of the State of Connecticut, Eric Russell.
Thank you, and good morning. Senator Fletcher, I'm not sure if is on virtually, but Representative Blumenthal, Senator Sampson, Representative Mastrofrancesco, and distinguished members of the Government, Administration, and Elections Committee, thank you for the opportunity to testify in support of Senate Bill 1434, an act implementing the Treasurer's recommendation on revisions to concerning unclaimed property. The committee has my written testimony, which details the technical changes in the bill aimed at improving the processes for receiving, managing, and distributing unclaimed property. I want to start by expressing my gratitude to the committee for raising this bill and for your ongoing support over the last couple of years in helping to modernize the state's unclaimed property program. Your efforts have allowed my office to implement significant process and technology improvements that have made it faster and easier to reunite residents with property that rightfully belongs to them. One of these enhancements was launched in April of 2024 called Fast Track, and it automates payments to sole claims under $2,500 where data matching tools show that the claimant is the rightful owner. This fiscal year, over 15,000 claims have been approved through that process. And as a result, we've paid out a record number of claims in recent years. For example, in fiscal year 2024, we returned $82 million to over 44,000 rightful owners, one of the most successful years that we've had on record. And since the program's inception, we have returned more than $1.1 billion in unclaimed property to individuals, businesses, and organizations across Connecticut. I'd be remiss if I didn't take this opportunity to encourage everyone in the room, as well as those watching on CTN, to check ctbiglist.gov, which is the website for unclaimed property. With tax season upon us, I usually advise people to check on an annual basis and kind of tie it to their normal tax review as unclaimed property is added on a regular basis. But these assets could include things like checking or savings accounts, unclaimed or uncashed checks, stocks, bonds, traveler's checks, money orders, or even life insurance proceeds. So I urge the committee to support Senate Bill 1434 as it will further and strengthen our ability to efficiently manage unclaimed property, and appreciate your time and consideration today. And with that, happy to take any questions you may have.
Thank you, Mr. Treasurer. Are there questions from the committee? Representative Mastrofrancesco.
Thank you, Mr. Chairman. Thank you for coming. Always appreciate your testimony. There's information in your testimony about funeral services. Can you talk about that for me, please? Thank you.
Sure. So the funeral service program, funeral service contracts are currently regulated by the Department of Consumer Protection. The change under this statute would provide that there were that contracts where an individual pays for funeral services in advance. So we often see this when individuals are paying down assets to qualify for Medicaid. And so a lot of times we'll purchase funeral services in advance. And a lot of times those contracts are not actually followed through. So either the funeral services are paid separately by a family member, and then those funds that were paid to the funeral service essentially are unclaimed property that belong to the estate of the individual that has passed. What we are doing in this statute is clarifying when those assets would be determined to be unclaimed, and then when they would be turned over to the state so that they could then be moved into the unclaimed property system and then be returned to beneficiaries of that estate.
Thank you for that explanation. So what is the time frame right now? Is that when they go over to unclaimed property?
It's not specified, which they don't go over to unclaimed property as is. There's no requirement that that money is turned over to the state.
So are what we trying to do require that it is turned over to the state from the funeral home? Am I understanding that correctly?
Correct. So to clarify, when those funds become unclaimed property, and then when they are turned over to the state to be a part of the unclaimed property system.
Okay, gotcha. So currently, right now, someone will pay for their funeral expenses up front. That money goes to the funeral home. It's never used for whatever reason. And what happens to that money? The funeral home what happens to
It
it?
sits in escrow. It's required by law to go into an escrow account when someone does prepay for funeral services, but there's no process or statutory requirement for those funds to be turned over. And so what we're specifying is just, a year after receiving notification of the death of the beneficiary of that, to the funeral home, that they would turn over to the system. And so we just specify the timeline for when that would actually take place.
Okay, thank you, through you, Mr. Chairman. So we're saying that if somebody passes on, they don't use those funds that they pay the funeral home. We're trying to get them into the hands of unclaimed property so people can properly and rightfully so the family can collect that money.
Correct.
Does a funeral home not do that? Like if they know that the person has passed and it's never used, what is their process? And I don't even know if you can answer that question
Yeah,
for me.
I don't know exactly. I think there are probably some funeral homes that are doing it, that are more proactive about it, and some that are not. And this is part of the reason why we want to make sure that there's a process and people understand how that should happen.
Okay, thank you for the explanation. And just one more thing, I did see something in the bill changing a time frame from 50 years to 75 years. Did we have anything like that, or maybe it was?
Not 50 years to 75 years. I don't know if there's a piece of the bill that requires a minimum threshold for notice that's being sent out for individuals with unclaimed property. And what we wanted to do is set a minimum threshold of $50 for when those notices are sent out. And just so you're aware, the way it's set up right now is we send out mailings. We're required to send out mailings to anyone with unclaimed property, and with no minimum threshold. And so what's happening is, we may have someone that is owed 25 cents that we're sending. It's a really big process and costs a lot of money to send out these notifications and then do the same thing to send out a check at some point. This unclaimed property would still remain, and the plan is to still pay those individuals out, but that we wouldn't be required to send out that notification under that $50 threshold.
Gotcha. Thank you. I obviously didn't have my glasses on when I read that part.
No, it's and I think that's the piece that you're talking about.
Yeah,
But if you have some follow up after, we're happy to.
Yeah, no,
make ourselves
that's
available.
fine. Okay, so I understand this correctly. And has there been discussion with the funeral homes on this? Do we know?
We have not been directly in communication with the funeral homes at this point.
Okay. Thank you so much for answering my questions.
Of
I
course.
appreciate it.
Thank you.
Okay.
Thank you. Questions from the committee? I cannot see the Zoom right now on mine. So is there anyone on the Zoom who has questions? Murray, if you could take a look. Okay. All right. Well, I will ask a few questions myself,
Sure.
partially to Vamp, but partially because I think it's important for public education. So, Mr. Treasurer, thank you for being with us today. Thank you for all your work over a number of years working with us on this bill. I'm really hopeful that we're going to get it across the finish line this year. I was wondering if, I'll put it this way, we've dived straight into some of the naughty details of the bill. I was wondering if you could back out a bit, tell us a bit about the unclaimed property program, how it has worked in the past or not worked in the past, and the steps that your office has taken to try to make it work better for the people of Connecticut.
Sure, and I appreciate the question, Representative. So this has really been a big priority for our office in trying to get money back to rightful owners. What happens with unclaimed property is there are funds that may be held by holders. These, again, could be funds that were owed to individuals. It could be a check that wasn't cashed at some point. It could be a dentist office that owed you a refund and you changed addresses and they were never able to get that check to you. These could be things that were passed down from a life insurance policy or from an estate at some point that are owed to you. But all of those funds that come in, they come into the state. And we track all of that. All of the unclaimed property that exists is updated to our website, which is ctbiglist.gov. And individuals can go on that website, can see if they have unclaimed property, and then can file their claim there. The way that it has worked historically is when those claims are filed, we have our unclaimed property team in the office that was manually processing every single claim that came in. And so again, that would be the same process, whether that was a 25-cent claim or a $25,000 claim. And it was very time consuming. And, our first responsibility is making sure that we're safeguarding the funds that come in. There is a lot of fraud and fraud attempts that take place with unclaimed property. But then our next goal is to get that money back as efficiently and as quickly as possible. What we've really been working on is modernizing the system, updating technology, particularly for a lot of the claims that are a little bit easier to process, where there's a lot of identifying information, where chances of fraud are low, where dollar amounts are lower. And so we've put new systems, and this is a testament to the support of the legislature, that we've been able to really improve technology and modernize that process, so we've been able to get funds back to people more quickly. And the goal with that is really to free up our personnel in the office to spend more time processing these more difficult and challenging claims, the high dollar claims, so that we can also get those funds back to people. And so this proposed legislation is the next step in that direction, as we continue to make changes internally to really speed up the process and make it more efficient.
Thank you very much. So it's fair to say it seems like that, well, I'll put it this way. Most of the unclaimed property fund is money that belongs to people, to individual Connecticut residents or businesses, and somehow it just didn't find its way there. And so I'm never sure how to pronounce this, but it gets escheated. Did I pronounce that
That's
correctly,
right.
Mr. Treasurer?
And there's a few different variations, depending on who you talk to, but escheat is what I say as well.
Okay, so it gets escheated to the state, which basically means the state is supposed to be holding it in trust for the person, I guess.
Correct.
I'm probably not exactly saying it correctly, but it's your office's responsibility both to try to get the money to the person, but also to make sure that it doesn't essentially get stolen by someone representing themselves as the person.
That's correct, which happens often. And, from a state perspective, the reason that is a challenge is because we are not only responsible, if we pay out a claim, a fraudulent claim, we are still responsible to the rightful owner to pay that claim out as well. And so, we work very closely with other states across the country that have similar programs. It's actually, if folks are interested, there's another website called Missing Money that will allow you to search for unclaimed property, not just in Connecticut, but across other states as well. But we work to make sure that we're staying on top of the most current things happening in unclaimed property across the country. You'll see with a lot of the attempts at fraud that there are kind of consistent themes that are taking place, or efforts that are happening across state lines. And so our goal is, again, to safeguard that, and then to try to make sure we're getting money back to people as quickly as possible.
Well, we thank you for your work on this issue and on implementing this program. Obviously, in the past, there were significant issues before your time that were brought to light, and we appreciate that your office's diligent work on trying to make the program better and administer it better, and to appropriately balance the desire and rightful desire to get money back to people who are owed it, while also making sure that that money is safeguarded. And I guess my final question, could you just say the websites that people can check for whether they're owed money that you're holding for them one more time?
Sure. So ctbiglist.gov is the website for all unclaimed property in Connecticut. You can go online there. You can search your name. You can see how much, up to a certain amount, how much that claim is worth, and go move forward with processing your claim right there on the website.
I may make a claim against this microphone.
Against the microphone?
But thank you, Mr. Treasurer. Again, appreciate all your and your office's work with the committee to strike this balance to make the program better. I know I'm hopeful. I think across the aisle, we can say we're hopeful that we can continue to improve it this year, and we'll continue to work with you on that. Are there further questions from the committee? Representative Master Francesco for the second time.
Thank you, Mr. Chairman. Sorry about that. as you were just talking, I had actually two more questions.
Sure.
I found that part in the bill where it said 50 years. I thought I was losing my mind and there was something really wrong with my glasses, but it was in section 2.
This is related to the funeral services?
Yeah.
Yeah, so that's 50 years after the contract is executed. So there's essentially certain triggers for when the funeral home would be required to report that money as unclaimed property. So the 50 years after the contract is executed. So in theory, if you have, or the date the beneficiary would have reached 110 years old.
Okay.
So those are kind of the triggers for when those funds would be turned over.
I mean, it seems like a long time.
It is, but again, this is if they aren't notified. So these are the examples. If they aren't notified with the first threshold would be a year after the funeral home was notified of that person's death. In the event that they were not notified, those triggers are so that the money ultimately gets turned over.
Okay. But it wouldn't get turned over to the state according to this for 50 years. Am I-
Unless if they were if the funeral home was notified, it would be a year after that.
Right. But if they were not notified,
Correct. Then you would have essentially what we're trying to do is build in those mechanisms where we don't have control over the notification piece,
Right.
but that there would still be this requirement at some point when we know that the person who had actually paid has passed, that those funds would then be turned over to the.
thank
to
you.
the
Yeah,
unclaimed
it
property.
just seems like a long time. I don't know. Right now, there is no time frame that they have
Correct.
to turn it over. So you're starting with a time frame. Look, if nobody claims this and the year has passed by, after so many years, they have to return it over to the state of Connecticut. What would be in place if the funeral home is no longer in existence? And I think I just read something in the paper that 2 funeral homes might have merged. What happens if they close? To you, Mr. Chairman. Through you, Mr. Chairman.
I mean, the funds are, keeping in mind, the funds that are held by these funeral homes are in escrow. So it's not as if this would be money just in their regular accounts that would, so the funds are separated for that reason. So in theory, those escrow accounts should still be in existence.
Thank you. Yeah, no, and I understand that.
Yep.
What's, I guess, questioning is that if the funeral home closes, they're in escrow. How is a family to get up to know that?
Yep.
Right. And to get a hold of that funeral home if they're no longer there. So I guess that's just a concern. And then should these funds be turned over to unclaimed property, as you mentioned, what it will be our process to try to get in touch with the families of these people, because usually we try to get, there's no last known address. These people have passed. And sometimes it's hard to get in touch with the family. So what would be the process for that?
Yeah, so if the unclaimed property is coming over, again, we have this notification process, which in theory, I mean, some of this in theory should be going through the normal probate kind of process, and there would be notification around assets of the estate from that perspective. But outside of that, I mean, it would be the normal notification and outreach that we do from unclaimed property. And part of this is why we are consistently urging people to check for unclaimed property and really making it a part of the regular process. So that they would ultimately be able to see when these funds are turned over.
Okay. Thank you for answering my questions. Thank you, Mr. Chairman.
Thank you, Representative. Further questions from the committee? Representative Metapace.
Hey, Treasurer Rushel, I just want to say I have had used these process in the past after my dad. This was almost over a decade ago, and as you're talking, I can say that it was a very difficult one at times to try and get this sorted. And what you have on here does seem easier. And I will be honest, I've been looking up the names of some of us in here, and I think we should all check it out because
Yeah.
some of us show up on here. I know. I have something for you, Representative Master Francesco. Something on there. According to this, I'm owed $4 from Walmart or something like that as well. But these are all and I will tell you, I've been telling this to people for years when this was a little harder of a process to do. That you should definitely check this out sometimes, because I'm surprised to see it's like, oh, I'm owed 16 cents from something, but. Yeah, I would say this is a really good service to be able to offer to our residents. This seems much easier than the way his process worked. It was very difficult to call the office for every time. They say, hey, what's the status of my claim here? But I just wanted to thank you. It seems like this is going to be a process that will be easier for people. And I think everything you're doing seems like it makes a lot of sense to try and both streamline this and make it easier for everyday people, and apparently the people who are not totally sure I understand the exact reason for why it has to be this set number of years, but we'll go with it. Yeah. Thank you.
Thank you. No, I appreciate it. And again, it's a testament, I think, to the support from the legislature and us being able to make these changes to modernize the system. We are currently in the process of implementing the most recent change, which will be the allowance to have automatic payments. So again, as I kind of mentioned with the first piece of this in implementing some of the fast track systems, we're testing right now those automatic payments, which should help expedite the process here. So again, there's still work to do, but we're certainly seeing progress, and I think that that's reflected in the dollar amounts and number of claims that we've been able to increase over the last several years, and that we hope we can continue to build on moving forward.
Thank you, Representative. Further questions for the treasurer from the committee? Anyone on Zoom? All right. Thank you, Mr. Treasurer, for being with us today and your work on this bill. And I will just repeat for everyone, ctbiglist.gov. Check it out.
Correct. Thank you.
See if everyone on the committee is doing it right now. So
Perfect.
all right,
Thank you.
Thank you, Mr. Treasurer. Next up is Rodney Butler. Mr. Chairman, whenever you're ready.
Boston. Good morning, everyone.
Good morning.
Good. Actually, quick shout out to Treasurer Russell and the staff. I got an email last week from unclaimed properties at ct.gov, and I had a couple $100 then I had outstanding. So, and they reached out to me, so it was fantastic. It was like a little Christmas surprise. But well, good. Well, Kuikwas and Tatawa, good morning, friends. Senator Flexer, Representative Blumenthal, Senator Sampson, Representative Master Francesco, and the many honorable members of the Government Administration and Elections Committee. My name is Rodney Butler. As noted, I'm the proud chairman of the Mashantucket Pequot Tribal Nation, and I'm here today to speak in support of Senate Bill 953, an act redefining state contractor, prospective state contractor, and subcontractor to exclude statutorily recognized Indian tribes of this state for the purposes of campaign finance laws. And so I thank you for raising this important bill. Special thanks to Senator Austin and Reps Nolan and Wilson. SB 953 addresses an important distinction in Connecticut's campaign finance law by recognizing state and federally recognized tribes as government entities. With respect to the application of Connecticut's campaign finance law, the bill appropriately excludes state and federally recognized tribes from the definition of state contractors, prospective state contractor and subcontractor. For the purposes of the state of Connecticut, that's us, Mashantucket Pequot, Mohegan, Schaghticoke, Golden Hill, Pawgussett, and Eastern Pequot tribes. There's limited instances where we enter into a contract with the state or an agency of the state. Recently, we sought to enter into a contract with the state's Office of Early Childhood in connection with home visiting services provided by our Child Development or our Child Protective Services. It was that interaction with the state where we learned that state and federally recognized tribes are not on equal footing with other governmental entities located in the state of Connecticut in the application of Section 9612. The bill before you seeks to remedy this disparate treatment, and fixing this disparity is important because the application of this particular section to us and all the tribes in the state could inhibit our ability to contract with the state to provide valuable social services and the like to our communities. The language in the existing section clearly demonstrates that the General Assembly thought it important to exclude governmental entities and elected officials in the state from the limitations imposed on state contractors. Pretty clear that we are governmental entities, so you know, I think it's a straightforward issue that we're putting in front of you all today. And again, we just thank you for your understanding of this quick and easy fix, and look forward to any comments or feedback you have on it moving forward.
Thank you very much, Mr. Chairman. Questions from the committee? Representative Master Francesco.
Thank you. Thank you so much for coming in to share testimony today. I just had one question about the social services that you provide. Can you kind of elaborate on that and give me an idea what those services are?
We have a robust suite of social. I mean, we are a small town government, essentially. We have 7,000 citizens that we service, and we have full infrastructure, police, fire, social services department, education. And so from a social services perspective, it ranges from the gamut from behavioral health services. As I noted, we have a child protective services within Mashantucket. We have various heating support services, very typical that what you see in any small municipality. We provide those to our citizens at Mashantucket.
Thank you.
Thank you.
I don't have any further questions, but thank you for clarifying that. Thanks.
Thank you.
Thank you, Representative. Further questions from the committee? Seeing none, we thank you for being here, Mr. Chairman, and thank you for your testimony, your work on this bill. And yes, you are a governmental entity recognized by both the federal and state governments as such. And so hopefully we'll be able to make this clarification.
Thank you. I appreciate that. Thank you all.
Next up is Alex Knopp. Not seeing Mr. Knopp, so we will go to Michelle Gilman, the Commissioner of the Department of Administrative Services. Commissioner, whenever you're ready.
I'm sorry, Mr. Chairman.
Never mind. I'm sorry. We had a little confusion there, I guess.
Sorry,
All right.
thank you.
Alex, I see you on Zoom, although if you could turn on your video if possible, and then whenever you're ready, you can begin.
I'm not able to turn on the video, unfortunately, Mr. Chairman.
Okay, well, you can go ahead then,
Thank you.
whenever you're ready.
Chairs and ranking members, thank you very much for the opportunity to testify. I'm testifying today not to support or oppose any bill, but rather to support the GAE committee retaining principal cognizance over all legislation concerning election and campaign finance law and principal regulatory oversight over the State Elections Enforcement Commission. The issue of GAE cognizance is unfortunately presently contested and uncertain because the joint rules of the General Assembly assign jurisdiction over the State Elections Enforcement Commission and its related areas of policy and procedure to both the Committee on GAE and to the new Government Oversight Committee. Joint Rule 6 provides it to GAE. Joint Rule 23 has identical language providing cognizance to the new Government Oversight Committee. And I've attached the text of these two joint rules to my testimony. Well, what's the problem? Well, if you assign the same issues and the same agency to two different committees, there's a great opportunity that the end result will be inconsistent legislation, time-consuming efforts to reconcile different versions, and undermining a very important legislative principle that committees are the workhorses of every legislature, including the General Assembly. And if you have, again, two different committees with identical jurisdiction, this means that there will be confusion, there will be form shopping, and there may be time delays to reconcile differences. A clear example of this confusion is that yesterday, the Government Oversight Committee held a hearing on Senate Bill 1405. And that bill would impose sweeping changes on campaign finance and election law. It would change the appointing authority for the executive director of Election Enforcement Commission. It would affect the calculation of citizen election program grants. It would affect the timetable for post-election audits. It would affect the distribution of post-election surpluses. It would affect the conduct of municipal referenda and many other matters that historically were assigned to the GAE committee. I had the privilege to serve as co-chair of GAE in 1999, 2000, and 2001. And my concern for raising this issue with you is that unless there is some either formal or informal resolution, the end result will be time delay and confusion, which are the enemies of every bill that GAE passes. And I'm concerned that the result of this confusion will be that the good efforts of all of the members of GAE will be undermined by the need to deal with the concurrent jurisdiction of another committee, which, in my understanding, is kind of unprecedented here. So I urge you to try to deal with this issue either informally or by asking leadership to deal with an amendment to the joint rules. And when I was co-chair of GAE, we had the fourth biggest workload of any committee after appropriations, finance, and judiciary. So there's a tremendous amount of work that all of you do. There's certainly enough work to divide up with the Government Operations Committee. It's just that the question of jurisdiction over elections enforcement and election and campaign finance law ought not to be divided up. And I urge you to give some attention to this issue so that election law and campaign finance proposals that you make are not undermined by this problem. And I thank you for letting me testify on the matter of GAE jurisdiction generally, rather than on any specific bill. Thank you.
Thank you, Mr. Knopp, and it's always great to have a fellow House Chair of GAE on the line. We appreciate your testimony. Are there questions from the committee? So, let me check the Zoom. Seeing none, I had a quick question. So I guess the potential overlap in cognizance is, I'm reading the government oversight cognizance in the joint rules. Matters relating to the administrative functions of, I guess, the State Elections Enforcement Commission. Is that the potential joint cognizance that is at issue?
The way the rule is drafted, it's simply that the GAE committee should have cognizance over all matters relating to the State Elections Enforcement Commission. There's nothing about limiting it to administrative matters. That's Rule 6. Rule 23 has identical language giving exactly the same plenary and unlimited jurisdiction to the Government Oversight Committee.
But we also have complete jurisdiction over elections, correct? And it's just the administrative functions.
No, well, the way the rule is stated, it doesn't, you get your jurisdiction through State Elections Enforcement Commission matters, the way the rule is written. I appreciate that there are, supplemental matters that arise out of that, but the problem is that exactly the same language is in Rule 6 and Rule 23. It's plenary jurisdiction, not limited to administrative functions. That may have been the intent of one of the rules, but it was not written that way. And therefore, the language is as broad as could possibly be. Both committees have cognizance over all matters related to the State Elections Enforcement Commission. As I said yesterday, there are 5 or 6 bills that could easily have come from your committee, and when your committee publishes bills that were raised at one of your prior committee meetings on February 14th, there will be multiple overlaps of some of the same topics. The two committees may result in different drafts or different positions, but the cognizance is plenary and identical between the two committees. And I think that's the source of potential problems down the road.
Well, I appreciate your testimony, Mr. Knopp. I'm not reading the rules themselves the same way. I'm reading the only thing in the Government Oversight Committee as pertaining to this as administrative functions. Well, anyway, This may be a matter that is resolved at a higher level than ours, or we may have to have discussions with the other committee. I certainly think, issues related to campaign finance are closely tied to issues around elections, so they certainly need to be resolved in coordination. And I thank you for bringing this issue to our attention and
Good, thank you.
in government oversight to our attention. Seeing no further questions, we thank you for your testimony.
Thank you very much, Mr. Chairman.
All right. Well, now, Commissioner, whenever you're ready, you may begin your testimony. And the Commissioner will be followed by the Secretary of the State, Stephanie Thomas, followed by Nancy Brulé. I believe that's how you pronounce it. Commissioner, whenever you're ready.
Good morning. Thank you so much for having me. For the record, I'm Michelle Gilman, Commissioner of the Department of Administrative Services, and I'm joined here by Jenna Padula, who is the agency legal director and works under the Real Estate and Construction Services Division at DAS. So I will summarize our testimony since you have the copy before you and presented and posted on the website. But I am here to testify on behalf of Senate Bill 1432, an act implementing the Department of Administrative Services recommendations for revisions to provisions concerning contracting real estate, state construction services, and probate court notifications. And so Senator Flexer, Representative Blumenthal, Senator Sampson, Representative Mastro Francesco, and distinguished members of the GAE committee, thank you again for affording us the opportunity to testify on this bill. This proposal does make various changes to the statutes, some technical, others more substantive, but they all are in an effort to streamline agency processes and reporting requirements. Section 1 changes the threshold for projects and task letters administered and issued by DAS, really in line with where judicial and the constituent units of higher education currently are in state law, moving those thresholds from $100,000 to $300,000. Those thresholds haven't been adjusted since 1997 for DAS, and we think for efficiency, both for us and SPRB, that this small change makes sense, but also still maintains oversight and accountability within our agency and also within SPRB. I do want to acknowledge that our partnership and our relationship with SPRB is strong, and we appreciate their continued work and efforts, and we certainly respect their oversight and review of the work that we do each and every day. So I want to mention that, but again, think this makes sense. Just given that the threshold has not been changed in many years, and we have worked with you over the last few sessions on a number of these threshold issues where they haven't been adjusted based on inflation or over time. And again, this is one of those items that we think makes sense given inflation in the construction industry. Section 2 and 3 are geared towards saving dollars in our DAS budget, estimated between $30,000 to $40,000 annually around posting our real estate advertising online rather than in a newspaper when we're seeking space of more than 2,500 square feet. It is a minimal savings, but the governor and OPM are directing agencies, as you are, to find savings wherever possible. And we think this falls within that and trying to find some savings moving forward, but this does require a legislative change. Section 4 aligns thresholds for state construction services in line with a project definition that was amended last year in the session. We can certainly speak further to that. It's a bit more technical in nature. Section 11 eliminates quarterly reportings due to the legislature on 2 projects. One for the Greater Bridgeport Community Mental Health Center garage, which now that that's complete and operational, we feel that that report is no longer necessary for us to produce or for you likely to receive since it's done. And then the other project is for the Office of the Chief Medical Examiner. DAS is supportive, as we are to all other agencies around their construction projects when initiated. But at this time, OCME and OPM continue to discuss the future of that project, well, whether it's scope, funding or other associated matters. And so if we could remove the obligation of this reporting requirement, we can certainly, between OPM and OCME, continue to monitor and update you on the status of that project. In fact, I'll mention that at our finance subcommittee hearing shortly in the next few weeks, we will be talking through that project again there. But again, that's just for efficiency and again, to reduce some reporting requirements. Section 12 eliminates really a pandemic era reporting requirement around PPE, which vendors moved their business practice to a PPE model and posted those vendors on our state agency website so that agencies could purchase PPE during the pandemic. We believe that this is an outdated requirement now, given where we are. So we would just ask that that be eliminated. Again, this will allow our procurement team to focus on other pressing matters, which are voluminous for our state agency partners and others. And then lastly, sections 5 through 10 remove a requirement that the DAS commissioner receive probate court conservatorship notices. DAS has no standing in conservatorship cases. So for DAS or our collections team, this is an obsolete and unnecessary move on the part of our probate courts. So we think, and as noted, probate court is supportive of this change. It will help eliminate a burden for our overstretched probate system and also allow us, not to have to manage those notices. So with that, I'll complete our testimony. And again, both Jenna Padula, Attorney Padula, and myself are available for any questions. Thank you again.
Thank you, Commissioner. Questions from the committee? We'll stand at ease. Representative Mastrofrancesco.
Thank you. Thank you so much for coming in. In your testimony, you mentioned about raising the threshold for approval from the review board from 100,000 to 300,000. And I'm just curious as to why. I know inflation and things go up. I actually like the transparency that there's some oversight on that. Aside from the cost of inflation, is there any other reason why they're recommending that go up?
I can ask Jenna to provide more context. She works in this area day to day. Again, we, similar to what we've done in the last few years with the GAE committee in particular, raising our construction thresholds, looking at inflationary indicators around different contracts and where state agencies have independent contracting authority for construction projects or where DAS may administer those. We've adjusted many of those threshold issues over time where they're in statute. And I think that this would help with some efficiency within our team, providing, all of these task letters, through the course of the year. And then SPRB, given their strong workload as well, having to review all of those. So that's why we're suggesting this minor change, but understand their mission and also agree that their oversight is incredibly valuable and transparent. So that's why we're seeking this smaller change that would be in line with judicial and higher ed. But Jenna, I don't know if you want to add any additional context in.
I really don't have anything to add. The commissioner pretty much covered that. Yeah.
Okay, thank you. And then just one more in the bill on lines 75 through maybe 83. It talks about the DAS service selection panels, and it talks about the projects valued at currently 5 million. And that is recommended to raise that to 7 million. Can you talk through that for me? Explain that to me.
And I'm sorry, Jen, if you could just put your full name in the record before you begin your answer. Thank you.
Jenna Padula, Agency Legal Director for Real Estate and Construction Services. So this is a conforming change to something last year. I will explain it. It gets a little convoluted, but, and I'm going to use the word project, and that's going to mean a couple of different things in the course of my explanation. But last year, the definition of a project was changed from 500 thousand to 750,000. That particular definition of project means that's the threshold under which DAS does not have to formally advertise that project, that work. So we can use what we call a task letter to assign work up to $750,000 off of an on-call contract. Okay, so keep that in mind. Now, if you think that maybe the consultant who we're hiring is roughly about 10% of the overall project cost, okay, that means that the overall project might be about $7.5 million. But by statute, any project that is valued over $5 million, which used to coincide with the $500,000 project definition, requires a panel of 5 members, and on-call contracts selection panels only require 3 panel members. So we're left in a situation where once in a while, we may be using someone on an on-call contract for $749,000, which is appropriate and acceptable. But that whole project has a $7 million value. So that selection panel that we used to pick that on-call only had 3 members, where maybe we should have had 5 because the overall project increased. That's a way convoluted way of saying it's really a conforming change to match up to the project change last year.
Okay, thank you. Thank you for that explanation. It
Yeah.
is a little confusing.
Yeah.
So
100%.
are you recommending the panel go from 3 to 5?
Yes.
So it
Yep.
would conform to
Yep.
the change in the
Yep.
thing.
So either way, we would be covered. We'd have 5 people on the panel, no
Got
matter the value.
Okay, thank you for that explanation. Thank you, Mr. Chairman.
Thank you, Representative. Further questions from the committee? Senator Flexer.
Thank you, Mr. Chair. Good afternoon.
Good afternoon.
Starting towards the end of the bill, can you tell me what your agency does right now with the conservatorship notices that you receive from the probate court?
I'll need to get back to you with the absolute specifics, but right now it is my understanding that we archive them, we acknowledge them, but we just really file them. So that's my basic understanding, but I can certainly talk to our collections team for additional information around that. There are various responsibilities that our collections team under DAS integrates with around the probate courts and certainly recoveries. But these conservatorship notices, we've been told, are not relevant to the work that we do.
Can you tell me about the other work that you integrate with the probate court on?
Sure. I'd love to call up Eleanor Michael, who oversees our business services team and the collections team. We've brought on a new CFO. Deputy Commissioner Eleanor Michael oversees all of those teams and I think can speak more day to day about what those efforts involve in terms of the collections and the work that we do with our DSS teams and others around that.
Thank you.
Hi, good morning. Deputy Commissioner Eleanor Michael for the Department of Administrative Services. I don't have that answer with me here today, but I'd be happy to get back to you with more information on that.
Okay, thank you. I'm just broadly, I think our probate court system, as was just highlighted with some shocking news reports this week,
Yes.
can in times be a black hole. There's not a lot of oversight. There are not a lot of accountability for various things that are filed and oversight with state agencies. And so I'm just a little hesitant. I understand this is a small thing, but I'm a little hesitant to eliminate any oversight or requirements that these courts actually report to state agencies, given my growing distrust for some of the way the system operates and the individual courts operate. So I'm just put that on the record for you.
Certainly. I think our role on a more broad level is around recovery on, various assets with DSS and our other agencies and that collection aspect. And again, we can get back to you with the exact, relationship with that team and probate. But day to day, we do not do conservatorship work. And so I think we're erroneously receiving notices and potentially information as well that we are likely not not interested in having, and some of it may be sensitive information that's not relevant to our office, and concerned about, chain of custody around some of that as well. But we can provide more information to you.
And that makes a lot of sense. Thank
Okay,
you.
Thank you.
And then switching to section 4, in your testimony, you reference changes in the general statutes concerning the definition of project.
Mhm.
Could you detail what that was?
I'm going to ask Jenna Padula, our attorney again, who can provide information.
Yeah, Jenna Padula. That was last year, there was a legislative change that amended the definition of project from 500,000 to 750,000. Essentially, that's the level at which DAS has to individually advertise a project, or could, practically speaking, or can use someone on one of our on-calls.
What does that mean, one of your on-calls?
So by
What
statute,
you were just talking with Representative Master
Yep,
Francesco about?
yep, so by statute, the DAS commissioner can advertise for an on-call series. We have at least half a dozen of them, architects and different types of engineers. Of course, I'm gonna blank on some of the other series, but, and we may have anywhere from 3 to 5 consultants listed on an on-call series at a time. They usually last for about 2 years, and they have a maximum value, usually like maybe $1.5 million, 2 million. And we write task letters that describe the scope of work against those on-call contracts. So you kind of like draw down the $1 million, $1.5 million. And then when it expires, we advertise for a new series and get a new group of consultants to be on the on-call.
And why wasn't this change made as part of the overall change that was made last year?
I don't know.
Did you ask for it?
No, I don't even know that we asked for, I'm not even sure if it was our proposal to ask for the change in the project value.
Yeah, I don't recall.
I'm not sure.
We can provide more history around that, looking back at legislative history, but that may not have been in our
Yeah.
our area.
Okay, thank you. Thank you, Mr. Chair.
Thank you, Madam Co-Chair. Further questions from the committee? Seeing none, we thank you for being here today and for your advocacy and work on this bill.
Thank you. And thanks for all the work that you do as well. I just want to echo some of the comments made earlier. You have a very large charge ahead of you, and really appreciate working with you throughout the course of session. Thank you.
Thank you, Commissioner. Next up is the Secretary of State, Stephanie Thomas, followed by Nancy Brulé, followed by Peter Lewandowski. Madam Secretary.
Good afternoon, co-chairs, vice chairs, ranking members. I've submitted my written testimony. So today I'm just gonna focus here today on HB 7129. As you all know, the Office of the Secretary of the State is in the process of rolling out just shy of 3,000 new pieces of election equipment, tabulators, high-speed counters, and medium-speed counters. And this is our first update in almost 20 years. So when this type of update was last made in the early 2000s, the state negotiated a bulk discount for the purchase of the equipment, and then we passed along the equipment to Connecticut's towns, and it's always been their responsibility to maintain the equipment, and that is what everyone assumed would happen again this time around. However, we were alerted that technically under the law, instead of being able to transfer ownership of the machines to the towns, our office is required to lease them. So HB 7129 would codify the practical and efficient process that was used almost 20 years ago. Without this change, there are significant costs and burdens for both the state and the municipalities. First, the state would have to continue to own the equipment even though it has no control over it. and as an asset on our books, we would be required to tag and inventory the equipment and undertake in-person visual inspections every year. This would waste time, taxpayer dollars, as our staff travels to basements and storage rooms across all 169 towns to lay eyes on these almost 3,000 pieces of equipment. Not to mention how difficult it would even be to schedule these visual inspections since most of our registrars are part-time. Without this bill, towns would also have to enter into a lease agreement, as I mentioned, creating burdens for them as well. Whether they own or lease, the towns are responsible for maintaining the tabulators. However, many towns have come back to us citing the unnecessary expense for hiring their town attorneys to negotiate these leases. They also have had administrative burdens because once the lease is approved by the attorney, the legislative body in the town also has to approve it. We already have at least one real-world situation of a town that was due to get tabulators for an election they have coming up in April, but their legislative body meets too close to the election date to approve the lease. So as you can see, this is getting more and more complicated. We are already in the process of distributing tabulators. Full rollout is slated to be concluded by June. So we urge passage of this bill and also a quick process through the legislative through the committee and on the floor so that we can get this adopted. That concludes my testimony today, but since I have a few more seconds, I would like to recognize one of our stellar interns who is in the audience, Rebecca Dorsey. She's here today as part of our ongoing efforts to engage more people in the young people in the civic process. So thank you for your work, and I didn't mean to embarrass you. And that's it for me today. Thank you.
Thank you, Madam Secretary. Questions from the committee? Senator Flexler.
Thank you, Mr. Chair. Good afternoon, Madam
afternoon.
Secretary. Nice to see you. Thanks for coming here today. I just wondered, can you just walk through what happened 20 years ago and why the situation we're in now with tabulators is different than them? Because I just want to allay any concerns that might be out there. And also, can you talk about how your office has a partnership with the towns when it comes to the maintenance of these machines? You've dealt with a lot of that in recent years as the old machines were breaking
Yes.
more and more frequently and there was a scarcity of replacement parts. Can you just talk about that a little bit? Because I think there's a little bit of concern out there about
Okay.
the towns owning these tabulators, and I
Okay.
think some clarity will go a long way to easing passage of your proposal.
Sure. Obviously, I wasn't here 20 years ago, but my understanding is that, as I said, a bulk economies of scale. So the state negotiated the contract and then I believe gifted the machines to the towns for $1 or something such as that. But it has always been the case that once provided to the towns take over control of that equipment. So they pay any of the annual maintenance costs. This has always been the case. If something goes wrong and they go through all of their backup equipment, they have at times purchased new equipment, but it just has to be the same model. So this doesn't change anything about how things have worked for the last at least 20 years. I'm not sure how it was done with the lever machines before that, but it changes nothing. The main difference seems to be, and please, I'll call on my staff if I'm characterizing this incorrectly, that DAS has gotten more detailed in how contracts are administered across the state. And the Office of the Attorney General advised that if we did the exact same thing, it would not be in compliance with the new contracting standards. But I don't think anyone intended for anything else to happen other than what happened 20 years ago. So the Office of the Attorney General advised that we should make this technical change to existing law to allow this purchase or this gifting to happen. Do you think that's fair? Yes. Okay. I'm getting the thumbs up. Does that fully answer your question,
I
Madam
think
Chair?
so. And there was
Okay.
also a difference in who paid for the machines 20 years ago, I think, right? 20 years ago, they came from federal dollars.
Oh, I see what you're saying. Yes. There, through the Help America Vote Act,
Yeah.
a grant was given for the entire country to upgrade its infrastructure. So that's the funding that was used. In this instance, it was bonding.
Right. And so there's not really in practicality, there's not going to be any difference in how these machines are maintained versus the machines that have been used since 2006, 2008.
That's correct.
different
That's,
towns.
it's the same.
Okay. And your office is still going to be there to help work with the manufacturer, figure out what part needs to be made, figuring out what person might need to come and work on the repair, that sort of thing. You're still going to continue to be a partner in the way you have been.
Yeah, absolutely. Literally nothing else changes. We always stand by ready to take advantage of anything that we can do at our level to help bring down the costs for the towns. That's part of the reason we get involved negotiating the contracts and the maintenance agreements, etc. We also always get feedback from the towns. So if several towns are having a similar issue, we can go to the manufacturer and try to work through some of those issues, especially if the town doesn't have the expertise to do so. So absolutely nothing else will change.
Great. Thank you very much.
Quite welcome.
Thank you, Mr. Chair.
Thank you, Madam Chair. Representative Osborne.
Thank you, Mr. Chair, and thank you. This is tenuous at best. Thank you so much for being here today. If I'm putting on my hat as a municipality right now, I'm playing devil's advocate for a moment.
Yep.
While this proposal may not change the way that maintenance has been paid for in the past, it would technically change the way it is paid for in the existing legislation that that this proposal is seeking to change. And if I'm in a municipality and I'm looking at my budget right now, and I'm saying, gosh, I'm living in a world of scarcity and I'm living in a world of decreased municipal aid from the state, I'm thinking I'm going home to my Board of Finance director and she's telling me, no, Melissa, vote no on this. So help me understand, the level of cost that that even if it's a technicality, that it will shift back to our municipalities. Thank you so much to you, Mr. Chair.
That's factually not true. Nothing changes. Regardless of whether we gift it or we lease it, the responsibility to the towns remain exactly the same. They will have to maintain the equipment no matter what happens here. Yeah.
Thank you for that clarification. Thank you, Mr. Chair.
You're welcome.
Thank you, Madam Vice Chair. Further questions from the committee? Representative Mastrofrancesco.
Thank you, Mr. Chairman. Thank you, Madam Secretary, for coming in. So I think you answered a couple of my questions already. As far as a financial burden on a municipality, what I can see possibly happening is that the machines are newer, and if something happens to the machine, parts could cost a little bit more than they did in the past. But that hasn't changed. They would have to pay for that anyway. So when you talk about 20 years ago when they leased them to the towns, is that what
No,
they
they
did?
didn't lease them. They just gifted them.
They
Yeah.
gifted them. Okay. And
Or
finance.
they sold them, I guess, for like $1.
Okay.
I believe. Yeah.
So financially, is there anything different now for that? Did you mention that they were going to now be leased to the towns, or there's the same process? They will be gifted to the towns.
So
Through Mr.
under
Chairman.
current law, we would have to lease them. This change we're seeking is to be able to gift them. And the towns are pushing back on the leasing because it's creating a lot of undue burden for them. Some of them don't have experts on hand to negotiate the lease. To read through it is taking a lot of hours. Once it's approved by the attorney they hire, then the legislative body has to go through it. And they've been pushing back on us for a number of weeks, indicating how much of a burden this is, because it was that the towns also assumed the same thing would happen. We would negotiate this purchase and then gift them to the towns. So
Okay.
a lot of this is coming from the bottom up and also from our office because of the undue burden it's also a cost to the towns. They probably would have to pay people to come in at different times. We haven't even contemplated yet if both registrars would need to be on site at a time that we would have to come to inspect the equipment under a lease agreement. So the towns are really pushing back on this.
Okay, thank you for that clarification.
You're welcome.
Thank you, Mr. Chairman.
Thank you, Representative. Further questions for the Secretary from the committee? Seeing none, thank you very much for being with us. You're always with you, hopefully. But thank you for being with us today.
I'm always with you. Thank you. so much.
And we look forward to continuing to work with you
Yes,
in the future on this and many other bills this session.
exactly. I'm sure I'll see you next week. Thank you very much. Bye-bye.
Next up is Nancy Brule, and I hope you'll correct my pronunciation if I'm incorrect, followed by Peter Lewandowski, followed by Scott Gall. Nancy, I see you on the Zoom. Whenever you're ready, you can turn on your video and unmute and begin your testimony.
Thank you. Good afternoon. I'm testifying in support of Senate Bill 1433, which would provide protection for the home addresses of employees of the Office of the Attorney General from disclosure under the Freedom of Information Act. Senator Flexer, Representative Blumenthal, Senator Sampson, Representative Mastrofrancesco, and members of the committee, I thank you for this opportunity to be heard. I am an Assistant Attorney General and have been a public employee for the state of Connecticut for well over 30 years. I'm an officer and steward for our union, the Association of Connecticut Assistant Attorneys General, and I have heard the concerns of my colleagues at all levels. Threats against Connecticut public officials have become all too commonplace and frankly are growing, as you know all too well. Our attorneys understand the increasing risks of being public employees, but we seek this amendment to protect our children, our parents, and our families by having our addresses not publicly available under the Freedom of Information Act. The risk is real. Our attorneys go into court every day and address issues of Medicaid fraud, protecting neglected or abused children, going against convicted criminals who are suing the state police or judges or the Department of Correction. That puts a target on our back. I defend employment cases for state agencies and state employees. I have been threatened with gang rape by an employee who was fired for his misbehavior and who I successfully defended the state on. Yet he continues to communicate with me, and twice the state police have had to visit him, but he's been able to avoid arrest. Sadly, one of my younger colleagues who has had to be involved in further litigation that he's brought has had her 5-year-old receive veiled threats by the same individual who is noting what she looks like. This is very concerning. We are very proud to represent the state of Connecticut. We are talented and zealous advocates, but we ask your help in protecting our home addresses. Now, we have often heard that someone could find these on the internet. That might be true, but let's not make it any easier. The attorneys who work for the judicial branch, the CHRO, the Department of Correction, the criminal prosecutors, and the public defenders have their home addresses protected. We should too. because we are standing up for the people of the state of Connecticut and simply ask that we have that peace of mind that we can say to our families, your home address will not be disclosed under the Freedom of Information. We have our public addresses, phone numbers, bar discipline history, bar records, and
Your 3 minutes
we're
is up.
available on Teams.
Moritz?
So thank you for this opportunity. Are there any questions?
Thank you very much for your testimony. Any questions from the committee? Seeing none, we thank you for being
Thank
with
you.
us today, offering your testimony, and more generally for your service to the state.
Thank you.
Next up, I lost my list. Peter Lewandowski, followed by Scott Gall, followed by Jonathan Green.
Good
Mr. Executive
afternoon.
Director, whenever you're ready. Good to see you.
Thank you. Senator Flexer, Representative Blumenthal, Senator Sampson, Representative Mastro Francesco, and distinguished committee members. My name is Peter Lewandowski, Executive Director of the Office of State Ethics. Thank you for this opportunity to provide testimony in support of Senate Bill 1430, an act implementing the recommendations of the Office of State Ethics for revisions to the State Code of Ethics, which contains legislative proposals presented by the Office of State Ethics. I've submitted a written testimony, and I'll highlight here a few points. First, the bill makes necessary revisions to the Code of Ethics for public officials by extending the conflicts of interest provisions to public officials and state employees, non-state employer, and the non-state employer of such officials or employee's spouse. This change will impact General Statute Section 1-85, which deals with direct or substantial conflicts, and Section 1-86, which addresses potential conflicts. The statutory provisions which address substantial potential conflicts are essential provisions under the State Code of Ethics. In fact, they're most fundamental to any governmental ethics code and are quite common even in private sector codes of conduct. Most conflicts of interest provisions in governmental ethics codes address conflicts involving outside employment. Currently, under our state code of ethics, a public official and state employee, however, can take official action that provides direct financial benefit to his or her private employer. The proposed bill will address the present loophole, particularly involving full-time state public officials and employees. It is important to note that under this bill, a public official or state employee does not have a substantial conflict and may take official action if any benefit or detriment accrues to no greater degree than to any other member of the same profession, occupation, group, or industry. In recognition of the fact that Connecticut has part-time legislature, and most legislators out of economic necessity must engage in private non-state employment, this bill notes that an elected official has substantial direct conflict involving their outside employment or their spouse employment only if such official has actual knowledge the benefit will occur and the benefit is distinct from any other member of the same profession, industry, or large group. Still, even if an elected official is faced with a substantial conflict, the official may either abstain or prepare a written statement and describe the matter requiring action, the nature of the conflict, and why the official can act in, despite that conflict, in public's interest. The purpose of this requirement is simply to provide greater transparency in the process. I should note that this change will rarely affect members of the General Assembly, and only in a situation where the member is dealing with a bill that is exclusive to that employer and not the industry as well. And again, it's quite rare. And in terms of potential conflicts, this bill, I'm almost done here. Potential conflicts, this bill only applies to full-time employees and full-time officials. I'll stop here, answer any questions you may have.
Thank you very much, Mr. Executive Director. Questions from the committee? My co-chair, Senator Flexer, has a question.
Thank you, Mr. Chair. Good afternoon. Thank you for your testimony today. I just wanted to give you an opportunity to emphasize that last point you were making. The Office of State Ethics has put this proposal forward several years in a row, and it often meets its demise. I suspect partially because people don't understand who that section actually applies to. So can you just talk about that a little bit more? You said it's a permanent full-time employee or a full-time elected official. It's not legislators. Can you, I guess, what I'd ask you for is also an example of the kind of conflict that may be happening now because we haven't put this proposal into law. Maybe
Sure.
you're not comfortable doing that, but if you are, that would be great.
So to illustrate kind of in general terms, and yes, it's true. This bill really addresses concerns regarding full-time employees, full-time public officials who also engage in outside employment. To illustrate in kind of general terms, let's say you have an employee who is involved in grant making, and let's say their spouse works for a nonprofit or for some entity, and that official, let's say that grant has an impact on that entity. Right now, under the current law, that official or employee can execute the grant for the benefit of that employer. Under the conflicts of interest, kind of in the basic terms, that's a problem. That official should abstain from that official action of executing the grant.
Thank you. I think that's a really good and clear example, and the fact that we're not able to close this glaring gap is frankly frustrating to me. So I appreciate your effort to advocate for it once again and adding that additional information to the conversation. Thank you very much.
Thank you.
Mr. Chair.
Thank you, Madam Chair. Further questions from the committee? Seeing none, thank you again for your work on behalf of the state and for being with us today.
Thank you.
Next up is Scott Gall, followed by Jonathan Green, followed by Eric Coleman.
Thank you for having me today. My name is Scott Gall. I'm the Chief Data Officer for State of Connecticut at the Office of Policy and Management. Thank you to the chairs, vice chairs, ranking members, other members of the Government Administration and Elections Committee. I'm here from the Office of Policy Management to testify in support of Senate Bill 1431, an act implementing the recommendations of the Office of Policy and Management concerning data governance. It is a brief bill. There's two things in it, so I will try and be brief as well. But it makes two changes that I think are really technical changes to the state laws governing policies for data through executive branch agencies. Section 1 of the bill modifies the definition of executive branch agency that's in 4-67O, 467O-P, create the chief data officer role. They require executive branch agencies to inventory and catalog the data they collect from the public every year. They require them to develop plans to provide access to that data to comply with the recommendations from the state data plan. And so the list of agencies that we are using is out of date. It doesn't reflect some of the agencies that now exist. Some agencies that are gone are not there. So we're asking for this to be changed to the definition that we use for the state policies around information technology, so that our data and technology functions are lined up with one another, and that will hopefully provide a sort of more seamless framework. But that's technical change number one. Technical change number two is we have a reporting requirement under 4-67Z every year to provide a report to this committee on legal issues in interagency data sharing. I believe the intention was for that to be a one-time report, but we are dutifully submitting it to this committee every year. However, what it covers, it has not largely changed in the past few years, so you're getting a similar report every year, and some of what it covers is redundant with what's in the biennial state data plan that I also submit to this committee every 2 years. So if you're willing, we're making the recommendation to repeal the requirement for this report on an annual basis. If the content is valuable and of interest to the committee, obviously happy to continue producing it and providing it to you. That concludes my remarks. Thank you for the time today.
Thank you very much, Mr. Gall. Are there questions from the committee? Representative Mastrofrancesco.
Thank you. Thank you so much for coming in. Just a quick question on the reporting requirements that you were following. Can you repeat again to me where we would be able to find that report? So,
Yes.
so if this was removed, how would one get that report?
Yeah, so it's it gets reported through the same way that reports get submitted to this committee under 11-4A. So it's emailed to you, the I forget exactly the state librarian, the Office of Legislative Research, and we post it on our site. I believe it's it's required there that it's on the OPM site, and so we've got the reports going back to 2019 there. And in addition, the state data plan is reported to this committee, and there's a data analysis technology advisory board that it also goes to, and both of them are required to be posted to our website every time they're produced.
Okay, thank you so much for clarifying that.
Sure.
Thank you, Mr. Chairman.
Absolutely.
Thank you, Representative. Further questions from the committee? Do you have any? Seeing none, thank you very much for being with us today and contributing your testimony.
Thank you very much.
Next up is Jonathan Green, followed by Eric Coleman, followed by Joan Andrews. See you on the Zoom. Mr. Green, whenever you're ready, you may begin.
Good afternoon, and thank you to the chairs, ranking members, and distinguished members of the Government Administration and Elections Committee. My name is Jonathan Green. I'm a licensed funeral director, embalmer, and the legislative chair of the Connecticut Funeral Directors Association. We're one of the oldest and nationally recognized associations of funeral homes in the country, with over 220 rooftops, ranging from our large cities to extremely rural areas, including corporately owned and private family-owned firms. Thank you for raising Senate Bill 1434, an act implementing the Treasurer's recommendations for revisions concerning unclaimed property, and the opportunity to submit our testimony. CFDA supports this bill, which provides the necessary procedure and defined criteria for identification and remittance of unclaimed or abandoned funeral service contracts. In consideration of the triggering events in Section 2A, however, we request an extension from 50 to 75 years after a funeral service contract is executed before it may be deemed payable or distributable. It is the CFDA's experience that individuals can retain such contracts beyond that allotted 50 years. With the additional sections of Connecticut General Statute, Chapter 32, as referenced among the new and revised protocols, SB 1434 allows for the existence and correction of reasonable errors made in identifying these abandoned contracts. Ensuring a contract owner's ability to initiate an appeal and claim abandoned property is a vital protection for anyone who has entrusted their funeral arrangements. Reasonable errors precipitating abandonment could include a beneficiary's change of address or contact information without notice to the funeral home, or sharing incorrect identifying information such as one's birth date or social security number at the time of arrangements. Additionally, funeral service providers often care for individuals who cannot advocate for themselves, and they rely on the information and conduct from others on their behalf, such as their power of attorney, conservator, or guardian. As these individuals change residences, moving from facility to facility, sometimes entirely out of state, it's unfortunately possible for knowledge of their funeral service contract or even forwarding address to get lost in the shuffle. Additionally, unless expressly notified, funeral homes would have no knowledge of a change to one's agent, their fiduciary role, or contact information. Furthermore, CFDA supports the right to claim abandoned property by another in-state or out-of-state funeral home, which provides funeral services for a decedent. These firms, having had no prior knowledge of an unclaimed funeral service contract, have an interest up to the amount of the unpaid funeral expenses. Likewise, if an office or a department of the decedent's state of residence contributed toward the cost of the funeral services, they too should claim reimbursement from the abandoned property. SB 1434 protects funeral homes in possession of unclaimed contracts and entrusts us to deliver these assets to the treasurer. By implementing this revision to statute, funeral homes can offer further transparency to those with whom they have contracts in effect. The fiduciary responsibilities of Connecticut's funeral directors cannot be overlooked and must be held to the highest standards, as with the rest of our professional care and conduct. I'd also like to make a reference to concerns that were shared about changes of funeral home ownership. There are statutory protocols already in place for delivering notice to contract owners and ensuring the continued protection of assets for the beneficiaries. Thank you for this opportunity to testify, and I welcome any questions or comments.
Thank you, Mr. Green, for your testimony. Questions or comments from the committee? Representative Mastrofrancesco.
Thank you, Mr. Chairman. Thank you for your testimony. Yeah, I just do have a few follow-up questions when I was questioning the treasurer. So I guess I'm just curious, how common is this? I know in today's day, there's a lot of pre-planning for funerals. Maybe years and years ago, it wasn't. But how common is it that this would fall under unclaimed property, that the wishes of the person who paid for their funeral services up front don't fall through? Through you, Mr. Chairman.
I can't speak to an exact number of cases where this would happen, but in our estimation, this is a rather rare occurrence, especially given the triggering scenarios to highlight the abandonment of one's contract. For the most part, our concerns are mainly when the knowledge of the contract or the contact information is lost, and that the proper funeral home with the pre-need contract is never notified. Without that accurate knowledge, there's really no way of knowing that funeral services have taken place for someone with whom you have a pre-need contract. Now, if families were to contact us, notifying us of the death of a loved one for whom we have a pre-need contract, that's something we can verify ourselves, whether or not they are already aware that their loved one had created such a contract.
Thank you for that answer. And through you, Mr. Chairman, can you just kind of walk me through what the process is? Somebody pays for their services up front. I can see maybe them doing that possibly when they're young. Maybe they move out of state. And maybe perhaps the family is not aware that they have this arrangement already or this contract already in place. And they pass on, and the services are not utilized maybe through that particular funeral home. What is the process? I mean, how would that funeral home know that somebody has passed on, that maybe moved to another state? And if they did know, what would be the process of trying to locate that family? Through you, Mr. Chairman.
That's exactly our concern as well. As our treasurer commented, that this is likely part of the regular probate process, locating assets, making sure any unclaimed assets are identified. But the biggest issue is when this knowledge is lost, and specifically, as I referenced in the importance of having the correct information first supplied to a funeral home. If we're to open a pre-need account with one social security number that, come to find out, is not that individual's number, it's likely that through this regular research, the unclaimed account wouldn't be located because it's tied to an incorrect social security number. It's really important to have both accurate reporting and consistent reporting, both between owners, beneficiaries, funeral homes, and any responsible parties.
Thank you. So, for that answer. So the funeral home really would not know if someone had passed on and they had a contract in place to pay for their funeral services up front, unless somehow they were notified by the family. Is that correct? Unless
That's
you're
correct.
looking, I mean, unless the funeral home is actually looking. Would that be a fair assumption?
And even then, for a funeral home to search and through publicly shared information, it's important to make sure this is a correct identification. There's more than one individual with the same name living in the same town, perhaps with the same surviving family members who may be listed in an obituary. It's important to have accurate, vital confirmation of this information. Now, if there's an instance where a funeral home is contacted that a death has occurred, another funeral home has cared for the arrangements, it's a simple, regular process to transfer those assets to the other funeral home, or in certain circumstances, make the return to the next kin, the estate, the appropriate party. If we're notified in time and in a timely fashion, this is an easy issue to resolve and make sure that one's assets are properly used.
Okay, thank you. And then just one more question. The purpose of going from 50 years to 75 years, can you explain that again?
Yes, for a number of reasons. One, we have to acknowledge that people are living longer. And in the situation that a very forward-thinking individual working on their estate planning opens a pre-need contract at an early age, it's likely they would outlive that 50-year process. More commonly in our discussions and in our experience, we're concerned about scenarios where parents may open a pre-need account for their child who is in need of continuous levels of care, is receiving state assistance, and the expectation is that their child will survive their own passing, and they wish to ensure that their wishes and their care is continued after their own death. And it's likely that this could also be an extended period beyond 50 years from the time that contract's executed.
Thank you. You know, I'm looking at the testimony, and you are the only funeral home that I see that's testifying, that I see actually for testimony on this. So, are you speaking on behalf of all the funeral homes, or just the ones that are members of your organization?
So I'm speaking today as a representative of the Connecticut Funeral Directors Association, which is not the entirety of the state of Connecticut. However, any changes to statute and best practices, of course, carry through to every funeral home in the state. Whether or not they're members of our association, we advocate for every funeral home, more importantly, every individual in the state of Connecticut in receiving care from our funeral homes.
Okay, thank you so much for your answers and clearing things up for me. Thank you, Madam Chair.
Thank you, Representative. Are there any further questions or comments from members of the committee? Seeing none, thank you for your time and your testimony.
Thank you all very much.
Next, we will hear from Eric Coleman, who will be followed by Joan Andrews, who will be followed by Ann Spire. Forgive me for interrupting you, and I'm not quite sure if I should say Senator Coleman, Judge Coleman, but would you mind reaching forward and turning on your microphone? And we're very happy to have you here today. Thank you. You're not used to that chair.
But anyway, I was going to request that the vice chair from the State Properties Review Board is also present, and he's planning on testifying on this bill as well as another bill. May we consolidate our testimony?
You can, but you both have the same 3 minutes. We run a tight ship here. Sorry. I got to have the same rules for everybody. But perhaps we'll have some questions for you that give you an opportunity to extend. Welcome, Representative.
Good afternoon, honorable chairs and members of the GAE committee. Thank you for allowing me to address the committee. My name is Eric Coleman, and I am a member of the State Property Review Board. Joining me today is the board vice chair, Jeff Berger, and also present are the board director, Thomas Jerem, as well as board staff person, Josh Narath. We're here on behalf of the chairman of the board, Bruce Josephi, and the other members of the board. We're here to express our opposition to Section 1 of Raised Bill 1432, which seeks to reduce the oversight authority of the State Properties Review Board. Historically, Connecticut General Statute Section 4B 23I required the board to approve or disapprove within 30 days any consultant contract in excess of $100,000. As Commissioner Gilman testified earlier today, the constituent units of higher education and the judicial branch have different thresholds, 300,000. Those projects are more narrow in scope than the projects undertaken by DAS. 1432 seeks to increase the threshold, the triggering threshold for DAS projects to $300,000. Just by way of example, if the provisions of Section 1 had been in place during the period from 2021 to the present time, the board would have had oversight involvement in 30% fewer contracts. Concluding my part of the testimony, in 1975, your legislative predecessors created this State Property Review Board. And for 50 years, the board has served as a watchdog entity to ensure that the state's real estate acquisitions, leases, and construction services contracts with consulting architects and engineers would be in the state's best interest and free from political patronage, cronyism, nepotism, personal spoil systems, and friendships. So I'm urging you today on behalf of the State Property Review Board to remove Section 1 from Senate Bill 1432.
Thank you.
Thank you.
Thank you for your
Be
testimony.
happy to respond to any questions that you may have at the appropriate time.
Thank you. I do have some questions. Perhaps Representative Berger wants to say something general and also answer my question. If you could just sort of, we have a lot of new members of our committee this year. So if you could just sort of lay out in lay terms exactly what your board does and how the projects that you referenced, Senator Coleman, around higher education units, how a project at UConn, for example, is different than a project that DAS might run, and why you think it's appropriate that the thresholds are different, and why this proposal shouldn't move forward.
So, yes, if I could, Madam
Yes.
Chair, University of Connecticut projects do not fall under our review. DAS, however, does.
So as far as the constituent units of higher education are concerned and the judicial branch are concerned, I believe that the types of construction that occur on campuses, dormitories, maybe administrative office buildings, maybe some other facilities. But I think those types of construction projects are different than those that might occur under the auspices of DAS. The same with the judicial branch, those types of projects, maybe courthouses. I'm not even sure administrative offices would occur or would be placed in places other than courthouses. So I think the scope of constituent units of higher education are a lot different, as well as the scope of projects that have to do with the judicial branch are a lot different. I believe that we should support this bill, and I'm urging you to support this bill because in the interest of full disclosure, I am the second newest member of the State Properties Review Board. But in my short time, my limited experience and observation, I've seen that because we exist and because we have this oversight role, the negotiation of such contracts is done conscientiously. I'm fearing that if the threshold is increased as DAS is trying to do that there would not be that same kind of conscientiousness in the negotiation of contracts, possibly resulting in the waste and the lack of savings to the state. I think we serve a very good and useful and valuable function in an effort to keep costs down. And just one other experience that I've had in my short time working with the board. What I've seen happen 1 or 2 times is that a contract that comes before the board triggers some questions from the members of the board. And that contract may be sent back to the parties or to the agencies with some instruction to respond to the inquiry or to make some adjustments. And that happens. And I think that process results in transparency. It also results in some savings as far as the state is concerned.
Thank you. I appreciate that response. And you also talked about, if this change were to go through, your estimation is that your board would have oversight of 30% less contracts
Yes.
than what you currently review right now. Can you talk about why you think that's such a concern? Like what kinds of contracts have gone through your board in the last several years that would not if this proposal moves forward and became law? Either one of you can answer the question, but
yes.
I would ask Representative, I've neglected before to ask you to identify yourself by name for the record, for our
Yes, yes, Madam
transcription.
Chair.
Thank you.
Jeffrey Berger, Vice Chairman of State Property Review Board. Thank you. Yes, we have a table that we can provide for committee members that encompasses 4 or 5 years previous to 2025, which outlines the contracts that have come before the board and the contracts that would not come before the board, and its oversight capacity and protection of taxpayer dollars. And that averaged to a total of 30% over the course of 4 to 5 years, 22 1 year, 28 another, and we have a table we can provide members and for further review to understand the process and the potential lack of oversight.
Thank you.
So I believe that table that Vice Chair Berger has referred to is attached to my written testimony.
Okay,
So you should have that in your packet, Madam Chair.
great.
Um,
I'm going to review that right now. Thank you.
it-
Are there other questions from members of the committee? Representative Mastro Francesco.
Thank you, Madam Chair. Thank you so much for coming in. Thank you for the job the board does. I really appreciate it. I think transparency and oversight is very, very important. I'm just a little confused. Are you in favor of increasing the threshold in this bill? I thought I heard you say that, but then when I read your testimony, it said you are not. So I just want a
We're in
clarification.
opposition to increasing the threshold.
Okay, good. I would tend to agree with you because I like transparency. Can you tell me, in the course of maybe the last year, have any contracts been held up because of the review that the board is giving? And I know you had mentioned that some of them are sent back. There's questions, which I think is really, really good, and they're clarified. But has anything been held up because of the work the board has done?
I don't think, well, as I indicated, I'm among the newer members of the board. I don't think any have been disapproved, but as I've indicated, they've been held up and modified and then sent back.
Yes, so Representative, if I could also add to that, our review really has been ratcheted up. The timeframes have been ratcheted up. We normally process within 7 days now. From the time we receive all of the information that we are required to review, our review and votes normally stay within a 7-day time period.
Very good, thank you. And when you do have a question on the contract, you send it back to the department. Are they swift in getting the information back to you, through you, Madam Chair?
Yes, Representative, for the most part, they are. Our staff will identify these questions prior to the meeting and hopefully flush those out prior to the meeting and then a vote, and then make a recommendation for or against approval. So oftentimes the communication lines are open and are very active prior to the initial meeting for that segment.
Okay, thank you. And then just one more. Would you be able to give me an idea of how many contracts you review in a year's time? I know that might be a,
In
I mean, is there a lo-
2025, I think we've done 17 so far.
Under what this bill would cover
17 so far.
in 2025.
Okay, perfect. Thank you very much. I appreciate it. And, I think this bill has come before us in the past. The thresholds are always trying to be increased, and I'm certainly all about transparency and oversight. I mean, it doesn't hurt. Certainly it doesn't hurt for the state or, to help the taxpayer. Thank you so much for your testimony. I appreciate it.
So if you don't mind me further responding to your question, in 2024, there were 121 contracts that the board reviewed.
How many did you say?
121.
And Representative, you should have a breakdown in your testimonies that would show that and what would be affected by the outcome of the passage of this bill.
Perfect. Thank you so much. I appreciate it.
Madam Chair, if the chair were to ask a question in reference to 7130, as far as a real life example, if Madam Chair were to ask that, we would be able to provide a real life example for 7130.
Thank you very much. I appreciate that. First of all, thank you, Representative, for your questions. And I think it would be very informative to know more about 7130 and some real life examples of that.
Thank you, Madam Chair. If I could have our executive director come up to.
Only if it means he's not testifying later. Just kidding.
Yeah.
Come on. No, I know you are. That's
Right
the
there.
joke.
Right up there.
Is it on? Good afternoon to all members here on the committee. My name is Thomas Jerem. I am the director to the State Properties Review Board. And at the invitation of our vice chair, we can point out the genesis of the legislation under 7130 today actually came to us last year when the Office of Policy and Management issued a grant and aid to the town of Easton through 466G. The town of Easton had an issue with their ambulance headquarters in the center of town where they had to do some expansion that required additional lands. And part of the grant and aid that was issued, OPM had required that under this scenario, if they obtained their appraisals and the negotiated purchase price was beyond what the appraisals indicated, they would have to come before the board for our review and comment. And with that review and comment, we learned many things after working with First Selectman David Bindleglass with the town on how they approached this project. And it was years in the making. And my understanding is they just had referendum last month that passed in support of the project, so they'll be able to put a shovel in the ground. But with our review and with the oversight, it gave the town the ability to go back to the seller of the land, a private property owner, and say that, you know, we've had our negotiations, but we are now required to go before the board for this oversight function to ensure that there's great transparency in what we're doing. And at that point, the first selectman and the seller of the property re-engaged in working on refining the purchase price for the land. And it worked out to the benefit of the town. We also learned that, you know, when they approached obtaining the appraisals, they could have used a little bit more guidance in seeking out whether to retain a residentially certified and licensed appraiser within the state or a commercial general appraised licensed appraiser in the state of Connecticut, because the residential licensees have a very narrow scope with which they can work within, where the general appraisers can appraise anything, any piece of real estate in the state of Connecticut. It was a productive review. We had a great working relationship with the town in terms of how we can help and what to do going forward if they ever were put in this position before, you know, again, you know, some great ideas for them to follow through in the process. They were very good at what they did. They had all of the information that was needed for us to respond quickly and you know, work with them to go forward and allow them to proceed with their acquisition. And they're now fully designed and waiting to put a shovel in the ground.
Madam Chair, if I could also add, OPM had come directly to us to ask for our review. And under the context of 7130, this SBRB would only be for review and comment for the municipality and not approval or disapproval vote.
Thank you. Thank you for that clarification. Are there other questions or comments from members of the committee? Seeing none, thank you very much for your time and your testimony today.
Madam Chair, I also would like to recognize our newest member, which is former Representative Russ Moore, who now is on SPRB.
And former chair of this committee.
We've all come full circle, Madam
Yes.
Chair.
Yes. Thank you all very much. Next, we will hear from Joan Andrews, who will be followed by Ann Spire, who will be followed by Matthew Lesser. Welcome, Joan. The floor is yours.
Thank you. Good afternoon, Senator Flexer, Representative Mastro Francesco, Representative Osborne, Representative Johnson, and other distinguished committee members. Thank you for the opportunity to testify today. I am Joan Andrews. I am an Assistant Attorney General, and I am the President of the Association of Connecticut Assistant Attorneys General. We are here in support of Senate Bill 1433, an act exempting the residential address of the employees of the Office of the Attorney General from disclosure under the Freedom of Information Act. I want to thank the committee for the work that it did last year on House Bill 5447. We did get farther than we had in prior years, so maybe the sixth time will be a charm, but there is a real need for this bill. I wish I could tell you the issue was only academic, but it's not. The protection that it provides and it's a workplace safety issue for my members. So it is an issue that is important to my members. And as I often say to the Attorney General, I have my constituency and it's very important to them. So assistant attorneys general have been the subject of threats, harassment, stalking, grievances, complaints, death threats, really for nothing more than doing their job well. We've reported on prior threats. Last year, I told you about one where the judge was threatened, the prosecutor was threatened, and our attorney general representing the prosecutors in that case were threatened. There was a sentencing after the legislature adjourned last year. He did receive a sentence of 5 years. I've attached the criminal case, should you wish to look at it. And what I want to emphasize is that under the existing statute 1-217, the judge was exempt, the prosecutor was exempt, but the attorney general was not and received the same threat. And I don't think that makes sense. I encourage you to look, the logic of this statute would make sense to extend it to attorneys general because, and the other employees of our office, because it's the same group of people. In many situations, I've gone through the examples, our clients are exempt under the statute, such as in the child protection work that our assistant attorneys general in the child protection unit do. The Department of Children and Families is exempt. With respect to the public safety unit, the state police, prosecutors, corrections officers are all exempt, but not their most visible advocate in the courtroom. There are some awful specific instances. An assistant attorney general in our child protection unit, they do very sensitive, dangerous work. There's a reason that those proceedings are confidential. That was 3 minutes already. I accidentally signed up twice. Can I have 6? No, just kidding.
You did.
We both signed up, but in sum, if I may, the state spends a fair amount on security for our buildings, and there's this gallery of rogues at the front that aren't allowed in the building because they're a threat. Why would you give them our home address and send them to our house where our families are? I'd be happy to answer any questions.
Yeah, thank you for your time and your testimony. I do have a couple of questions. And I don't know how much detail you can get into on this, but I really appreciate that well, first of all, I'm dismayed that this year an added argument to your case for this bill that we've worked on for many years is this criminal case that you've attached information on in your testimony. To whatever degree you're comfortable or able, can you detail exactly what this person was convicted of, exactly what they did?
Yes, I have attached the judicial information sheet.
No,
which
I
is-
see this
that's
threatening at the
public.
second degree, violence to
Threatening at
terrorize.
Threatening second degree, violence and to terrorize. It's a 53A62. The individual was sentenced to 5 years in jail, execution suspended after 30 months, and then probation of 2 years.
Forgive me, I don't think perhaps I wasn't clear enough in my question. You said that before and I read that. I want to know what they actually did in lay terms.
In lay terms, and I have in prior
If you're
years, I've
comfortable, I'm
attached-
not trying to pressure
No,
you.
not at all. I'd be happy to tell you The individual threatened the AG, the judge, and the prosecutors, and said, and this is a quote, "Justice will be served the day I get out. You'll be the first one seeing me at your doorstep. If I was out in the world, I'd be at your doorstep. You can't hold me forever, Your Honor. Sooner or later, you're going to see my face and justice will be served." That's from one transcript in June of 2022. On another transcript, "I'm going to tell you to your face, again, both of you, you wonder why people walk into courthouses and McDonald's and shoot people. Trust me, one way or another, my justice is going to get served. There's justice that's going to be served the day I get out. Trust me. Bank on that. You and your, I've bleeped it, buddy are going to get it. There ain't no second about it. You're going to get on my dead mother's dead grave. I will get justice when this day is over. You can mark my words on that." And that's from a court transcript on August 4th, 2022.
Thank you. Thank you for detailing that. And I'm sorry that your members had to endure that kind of behavior in their public service to our state. You also mentioned in your testimony, an argument that we've heard against this a lot is that this is already publicly available information. And an argument that I've made frequently in advocating for this bill is that there's still something different about the government itself handing over this information when you are serving the public in these roles. And if you have an unusual name like mine, it's probably going to be you if it's Googled. But if you have a more common name, like perhaps yours is, it's not necessarily going to come up with search results that are accurate for you. And so this is still different for a lot of people who have more common names. Would you agree with that?
100%.
Yeah.
I know from my own search, there's at least 55 other Joan Andrews, one that was more prominent than me. So she shows up the most. But if you ask my employer under an FOI request, they can provide my home address. And we're suggesting that that should not be the case because really what this has become is it's a litigation strategy. It's a threat and intimidation strategy. And quite frankly, I think my members have pretty thick skins and it's their families, as Nancy Brulette said, they're concerned about. When you've left materials in an AG's home mailbox, not postmarked, meaning they were personally delivered, with addresses printed out from the AG's house to their child's school, and with direct threats again. I mean, that's not just, being tough in a deposition or taking an adverse position on a memo of law. That's a threat. And that's why there have been convictions. So they're lifetime protective orders but the illogic of another colleague of mine in the child support section, her life was threatened, and she got a protective order because her colleague right by her side in court from support enforcement is within the judicial branch and protected by the statute. So the logic of the statute doesn't make sense. I mean, I don't, and I know the world has changed since that statute was enacted, but I don't see anybody taking away the protections for those already covered. And it's because their jobs are sensitive. And there's a recognition of that when that bill was passed. It still is. So I think as the most visible member of the team in court, we're asking that our home addresses be protected. You can get us at work. We sign every pleading with our name, our address, our phone number, our fax number, and our email address. There's any number of ways to reach me at work, to reach my members at work. When it's about the state's business, that's where you should be contacting us, not at our homes.
I couldn't agree with you more. There's no public purpose for someone knowing where you live. Thank you. Are there other questions from members of the committee? Representative?
Thank you, Madam Chair. And thank you for being here today and raising awareness of this issue. Would you agree that other practitioners who may fall under FOIA but don't necessarily fall under the Office of the Attorney General, specifically, I'm thinking of the folks who serve as contract attorney public defenders. I served for a number of years on the juvenile panel. And at one point, I dropped my former married name because it was unusual and it was very easy to find me and to find my young children. And for the exact same reasons you're talking about, I felt it was necessary to do that for the protection of my children. And again, like you, there were members, there were people in the courthouse who were protected, and I was not. And would you agree that it would be sensible, to the extent that someone may seek a home address of a public defender by contract? Because again, they're not public defenders, they're contracted by the Office of the Public Defender, but our home addresses would have been there. Would you agree it would be sensible to extend the same proposal that you're putting forth for the Attorneys General, or Assistants Attorneys General, to those folks who are contracted through the Office of Public Defender as well?
The same logic would certainly make sense to me, and you could probably appreciate the statute covers public defenders. You're there effectively serving as a public defender, perhaps because the original public defender has a conflict, and that leaves you hanging in the wind. So
Right.
I would have to point out, if the request is made to a public agency like the Office of the Public Defender, that perhaps it should cover their contract attorneys as well.
That would have been a nice thing for it to have happened. But, you know, the people who serve as contract public defenders don't just serve as public defenders for parents in those scenarios, but they also serve as attorneys for the minor children and guardians ad litem. And as you know, people are much more upset about the disposition of what happens with their children than they are about almost anything else. And it is a very dangerous area of law to practice in. And I thank you for your raising awareness of this issue. And thank you for being here today. Thank you, Madam Chair, through you.
Thank you, Representative Osborne.
Thank you. Thank you very much. I see no other questions from members of the committee. So thank you again for your time and your testimony and your advocacy on this important issue.
Thank you very much. I appreciate your time.
Next, we will hear from Ann Spire, who will be followed by Matt Lesser, who I don't think will be followed by Jenna Padula or Jeffrey Berger, because they both already went. So it'll be Ann Spire, Matt Lesser, John McNamara. Welcome, Ann. The floor is yours.
Thank you. Hi. Good afternoon, Madam Flexer and Representative Osborne and Representative Johnson and Representative Mastro Francesco. I'm Ann Spire from New Britain. I'm Secretary of the League of Women Voters New Britain area, as well as chair of its ad hoc committee, which formed in 2021 for clear charter reform ballot questions. The League of Women Voters New Britain area strongly supports HB 7125, an act concerning referenda on revisions to municipal charters and home rule ordinances. This bill also has the support of the League of Women Voters of Connecticut. Municipal charter revision is just too important to be on the ballot without clearly stated questions. Voters are frequently asked to choose yes or no on the question, do you support the recommendations of the Charter Revision Commission? Most voters, unfortunately, have little or no idea of what those changes are, and the first time they become aware of the questions is when they see it on the ballot. This has happened throughout the state. This bill seeks to provide a safeguard on the language of these ballot questions so voters know what they're voting on for charter revision. This is the third year of our work to bring about this legislation. Last year's bill was about to go to the House floor for a vote in the last few days of the session, but it was pulled by the Speaker. While the language requiring clarity was strongly supported, there was concern that the proposal would make the ballot too crowded. After discussion with leadership, with our legislators, with the committee, we came up with HB 7125. It was created. It retains the well-supported section requiring clarity of language for ballot questions. It proposes 5 areas that would need to be clearly listed on the ballot if the Charter Revision Commission recommends changing those areas. They are: 1, to change the manner in which the governing body of a municipality is elected. 2, any change in whether officials are elected or appointed, or their terms of office, change in that. 3, any change in residency requirements for the head of any municipal department. That should be on the ballot. 4, the creation or elimination of any municipal board or commission. 5, any change in public notice for hearings that relate to the municipal budget process. People need to know when those hearings are. They're usually quite interested in them. Other proposed changes could appear on the ballot in a generalized overarching question, such as do you approve the changes of the other changes proposed by the Charter Revision Commission? Municipal governing bodies could also choose to recommend other area-specific questions. Of course, it's up to the GAA committee and the legislature to rework any of these 5 areas. We hope that you find our recommendations helpful, and we hope that it will support passage of HB 7125 this year. Thank you.
Thank you. Thank you for your time and your testimony. And I'll just respond for myself. We have found your recommendations helpful. That's how we got to this proposal today. So
Great.
I want to thank you, not just for your testimony today, but for your continued work on this and receiving feedback and trying to come up with different ways to solve the problem that I think you have pointed out that I personally think is a very fair concern to have. But I really appreciate how you've taken a lot of feedback into consideration and tried to change the proposal each and every year. So maybe this is the year.
Mhm. It's a work that needs a lot of input. We listened, we tried to reform it, and I hope it can go through this year.
Yes.
Let me give a minute of credit to League President Mary O'Brien, who's over there, and John McNamara, who is part of our committee, as well as the other members of our committee who I can talk to you about further if you should ever want.
That's great. There are going to be a few more questions, so it's not just me being nice to you. But I do just want to just say one other thing that I think often people don't understand the scope and variety of how municipalities are run in our state. There's just a lot of differences, and it's not a one size fits all approach. But I do think it's important for voters to know exactly what they're voting on, and so. With that, I'm going to call on Representative Mastro Francesco.
Thank you, Madam Chair. Thank you so much for your testimony and your explanation. I certainly understand the frustration. People can't really understand what's on the ballot. They see a question without any detail. So I absolutely share your frustration. It's happened many times. And in your proposal, it's only referring to questions on the ballot that relate to the chart, to the town's charter. Is that correct?
That is correct. It's very narrow.
Thank you. And do you have any opinion about questions on the ballot about just referendum? Just maybe there's a bond package that the town has to appropriate, and they need to put it out for a referendum. Again, I find that frustrating as well, because people don't really know what they're voting for. They just have a dollar amount on the ballot and they clearly don't understand it. Can you talk to that? Is that something that you would support?
Well, the bill does just impact charter revision. So it's not exactly for budget referendum, but any thoughts on it from me would be that perhaps major changes in a budget proposal could be spelled out on a ballot for a referendum, a budget referendum. However, this is narrowly defined as being charter revision.
Okay, thank you. Yeah, we had a charter change in our town not too long ago, and the question was on the ballot. People didn't really understand it, and I saw that they were on social media. They're saying, "Well, what does this mean?"
Yep.
And they clearly couldn't understand it. So I truly do appreciate it. Thank you. Thank you for your testimony.
We stumbled into this because we were just doing typical League of Women Voters voter registration at supermarkets one summer and autumn. There was charter revision too. We handed out just information with no opinion, but information as to what's on that charter revision. People's mouths dropped open and they were quite upset that they didn't know what those questions were and that they were being asked to vote for things as a clump when they wanted to say yes to this, no to that. We found a lot of anger. A lot of frustration.
And I can
for the process.
And I can see that too. And I always say that people should really get involved in their town government to know what's happened. But I understand people get busy. They're not at every town meeting. And the information needs to be out there for the voter to understand. And all of a sudden it passes and they're like, well, what happened? And often people say, well, we had a public hearing on it. Nobody showed up and so forth. And I get that. People are very busy. And they don't have time to attend everything. So it's our responsibility to make sure everything is transparent for them. So thanks again for your testimony. Thank you, Madam Chair.
Yeah, I agree.
Thank you, Representative. Representative Blumenthal.
Thank you, Madam Chair. And thank you, Ann, for your testimony today and all your work on this bill. I was wondering if we could just back up for a moment and you could just tell us, or anyone who's watching, what is a charter?
A charter is the constitution of a city or town, a municipality.
And so whatever's in the charter, that limits what the municipality can do for at least usually roughly the next 10 years. Is that fair to say?
Usually, the state law, I believe, requires charter revision every 10 years, which doesn't mean you have to make changes, but it means you have to look and see if you should.
Okay. So, I think that's super important for people to understand when they consider this issue. Charter is the constitution of the town or the city. It puts potentially a straitjacket on what your local representatives and your mayor can do. It could eliminate boards and commissions. It could create them. It could change how they work fundamentally in ways that have dramatic impact on life in your municipality. And what in the charter referendum that spurred you to work on this bill, you may have said it earlier, and I apologize if I missed it. Do you know what the turnout was?
It was very low. I'm looking at John McNamara, who's very good at these things. Okay.
Okay. Well, I'll ask him. Suffice to say, I would presume it was quite low.
Yes, because people see a question that they don't understand, and so they just move on. They don't vote for it one way or the other.
So, I think first of all, thank you for bringing this issue to us. Thank you for working on this bill. I think you've done a great job of, following it year over year. Usually things take a couple years to get it right. And I'm hopeful we'll be able to get it done this year. But, these are critical issues for our towns and our cities. The charter is unbelievably important. And usually charter referenda are low turnout. They're low information. They're not, on the news. And at the very least, we should be making clear to the people what they're voting on to the greatest extent possible and trying to give them options, not allowing everything to be jammed together. So I'm hopeful that we'll be able to continue the work on this year and get across the finish line. And I would ask you if you're willing to work with us on further crafting the bill, but I know you are. So I appreciate you being here. Appreciate your testimony and your work on this issue.
Okay, well, thank you. Anything else I can do for you?
No, but thank you very much for your time and your testimony.
Thanks to you all.
Thank you.
Have I left my pencil down? Run before I do this.
I don't see the next person who signed up to testify in the room or online, so I will make Mr. McNamara's statement true and call upon him next. Welcome, John. The floor is yours.
Thanks, Senator Flexer, Representative Blumenthal, all the members of the committee. I just want to back up what you just heard briefly about this bill, HB 7125, that revises state law covering municipal charters and home rule ordinances. As an elected official, now responsible for putting referendum on local ballots, I'd welcome state election law establishing new standards. As it stated in the legislation, a precise and fair explanation of the proposed changes on the ballot. They need to be written clearly and unambiguously. And that's why I'm back again to support the league and the work of this committee. It's a reform needed to give local commissions and city councils specific criteria to avoid the one-size-fits-all question. Do you approve the recommendations of the Charter Commission with no reference to what those changes are? Excluding, of course, catching up with state law language and other minimal changes to modernize our charters. I think it would also head off challenges or disputes from citizens who oppose charter changes from time to time that municipalities need to consider and adopt. In New Britain, we now have a standard review of every 5 years to look at the charter. And for those specific reasons that's now in the bill that Ann cited, I think it provides good clarity to local officials like me, and will head off people feeling they got railroaded, like to Representative Blumenthal's question, happened in New Britain in 2022, a state election, where I guess it was not enough, but maybe 54% or so, which is a good turnout, actually. If it's not a municipal election, we won't go there. But we want to improve on that. So as I've seen in New Britain and heard from other communities, the voters' right to know what they are voting on is too easily violated. I included my written testimony, research from Civic Design about the confusion, a general question that essentially changes your form of government. The harm it does, it makes people cynical, it makes them less likely to vote. So I'd urge you to move this bill if you can. It's a long session, you got more time, and I'd be happy to answer any questions. If I have a little more time, the Britain situation was 5 substantial changes. Changes the way, I spoke too soon. Clerks and tax assessors from elected to appointed, creating a COO in a strong mayor's office, and essentially making substantial changes that people had a right to know. I wonder how many people in New Haven last year voted knowing they were changing the mayoral term from 2 to 4 years. I wonder how many know that because it wasn't on the ballot. Thanks for your time.
Thank you. Thank you for your testimony. Sorry, the statement you just made at the end was somewhat shocking to me.
I'm
What was
not-
the question on the New Haven ballot?
I think it made some substantial changes.
No, I know it had a lot, but what was the actual question a voter could read? Do you
well,
happen to know that off the top of your head?
No, I'm speaking out of turn, but I believe I read where it was mayoral change, a change of that, and other kinds of aldermen. I think there is testimony from somebody in New Haven who makes that complaint. I think you'll find it in either the written testimony or what I saw from what was submitted the other day. And it just meant, not that you can't make a good case for things like this, but in New Britain, it was to make these substantial changes, and nobody knew what they were voting on. The bone of contention was we have a mayor council form of government with a mayor that's finally getting compensated rather well, although the current one is leaving, but creates essentially a town manager that was tried in Hamden, I think, a year or two ago, and was shot down. So I was for maybe having a appointed clerk or assessor for professionalism, but opposed to the COO, but I didn't have that choice.
Thank you. Thank you for your testimony. Are there any questions from members of the committee? Representative Menapace.
Hi. I just want to say that we also recently had a charter revision in my my town, East Lyme, and they did choose to break those down by the individual changes. I will say, and I wasn't sure if you had any input on this one, that we still ran into a lot of people who felt very confused about just the nature of these ones. Some of these, get into a little bit more of like procedural questions, and I wasn't sure if you guys this one have any recommendations of what we can do to ascend. I mean, there's only so much we could do, I suppose, at a certain point to break down what this change will do and have it still fit on there. I know this was a rather long ballot that we had that went onto the backside, and so you'll notice that those ones got a lot less votes on them as a result.
No, election officials, and I think Secretary Thomas and local election officials have a problem with flipping the page on that. I recognize that, but I think it's quite doable to keep it in a clear way, to have the single issue or a couple of issues cited in the question itself. without being excessive. I can't recall seeing any testimony received over 3 years. Everyone seems to say, this is a good idea, but we got technical problems with it, which are understandable. But I think you can find a way to have sunshine on when you're changing your form of government or the way your government operates. And I've looked at this, I think another part of election law that needs to be looked at is the manner in which the information is shared. We generally in New Britain, we didn't have anything on the website about this in detail on the 22 referendum. And we essentially use a 19th or 20th century poster when you walk into the voting place. And they do distribute information about it, but it's usually an 8 or 9 point fine print where people like me need stronger glasses than I have on now.
Thank you.
Thank you.
Thank you. Thank you for your, we have more questions. I'm going to debate who should go first, me or you. Okay.
Close out your chair.
Oh, okay. So, I just have one question. I found that question about New Haven, in the testimony that you referenced. It says, shall the city approve and adopt all other charter changes as recommended by the Charter Revision Commission and approved by the Board of Alders? That's what it said when they were lengthening the terms of office, and
Yeah.
it's just shocking, honestly, as this committee is considering a proposed change to our state constitution around legislative terms of office and the requirements that we have in terms of it being a clearly worded question, one that people understand the consequence of, the process we have in this legislature for the accompanying explanatory text that's written by nonpartisan staff in this building to make sure that people understand the question when it does appear before them to change our state's constitution, as we've done several times in the last decade. It's really kind of stunning to see how vague the language can be for, as was described earlier, these municipal constitutions.
I've talked to my good friend Steve Mednick, who's an attorney in New Haven, who deals with a lot of charter changes. He has in the past in New Britain. We have a slight disagreement. He can make a case for that kind of one size fits all question very well, but I think it doesn't serve the voters very well. It discourages voters, and I think looking at this kind of legislation, mainly for state referendum in other states, they do 19 or 20 have single issue, and in some localities in some states, single issue requirements. And I think it would be also good in the future the committee to look at the manner in which, despite 169 different ways of doing it, the manner in which the pre-vote before the election, the information gets out to people. I think that would be a good area to look at too.
Great. Thank you.
Thank you.
Representative Blumenthal.
Thank you. Appreciate your testimony, being here with us, and certainly the New Britain situation was pretty disturbing, I think, to a lot of people. And
Actually, it was the reason I ran for council. I was looking for somebody else to be here.
well, we're glad you're here. I appreciate it. I was just looking up. We had a charter revision referendum in Stamford in 2023 that would have made quite fundamental changes. We had a 29% turnout. Ultimately was rejected, but I think anything we can do to shine further light on charter changes, make sure the public is better informed and hopefully better involved in the process is vital and urgent, because charters are super powerful and important, and they determine the course of your city or town for the next 10 years.
That's one more thing, point of changing the state statute, because I've asked more than once on the Council of New Britain of the Corp Council, does state law supersede the charter? And the answer is yes. So I think councils will act in good faith if they have that guidance in the statute itself.
Well, I agree, and we appreciate your testimony and your work on this bill and this issue.
Thank you.
Thank you, Madam Chair.
Thank you. Thank you again for your time and your testimony. Next, we will hear from Senator Matt Lesser. Welcome. The floor is yours.
Good afternoon, Senator Flexer, Representative Blumenthal, Ranking Member Mastro Francesco, Representative Manapace, and anybody online, members, and sorry. You just walked in, Representative Osborne. You too. I apologize. And members of the Government Administration Elections Committee. For the record, I'm Senator Matt Lesser, and I'm here to testify in support of Senate Bill 1163, which is a very simple bill. It simply seeks to clarify that all moderators, including head moderators, should be certified. This is a good way to ensure election integrity, that our elections are conducted properly, that our poll workers, our election workers have the fullest training possible. I will point to the support of ROVAC and the Secretary of State's office, which I think is really helpful. I can also speak to some problems that are caused by not having this. Specifically, there's a requirement in 9-229 that says that certified moderators cannot have been convicted of certain crimes of moral turpitude, including fraud, embezzlement, etc. That does not apply to non-certified moderators. I think that is a loophole that was not intended by the legislature, but we can fix that by passing this bill. Happy to take any questions, and thank you for your attention and time this afternoon.
Thank you. Thank you for your time and your testimony. And thank you very much for bringing this error or loophole, as you described it in our law, to our attention. And hopefully we can solve that this year.
Great. Thank you.
Are there any questions from members of the committee? Seeing none, thank you very much for your time and your testimony.
Have a great afternoon.
Thank you. You too. And I believe Yoshana Rath has also left. I'm going to call one more time. Yoshana Rath. Okay, and then I believe the last person we're going to hear from today is Scott Drexel.
Okay, thank you, Madam Chair, Mr. Chairman. I'm here on to speak in support of HB 7127, and I'm here on behalf of an organization called the Coalition for Fair Software Licensing. It's an organization comprised of American companies representing a cross-section of key industries, including healthcare, financial services, manufacturing, software, and cloud and cybersecurity providers. So very simply, the purpose of 7127 is very simple. It's to ensure that when the state enters into a contract for the purchase of software that's designed to be freely deployable in any hardware or cloud environment, that the state is not artificially restricted in choosing the infrastructure environment that best fits its own business needs. So the need for this legislation arises out of growing concern among IT leaders, procurement offices, and regulators around the country, and in fact the world, that restrictive licensing practices are leading to wasteful government overspend, that it creates unnecessary cybersecurity vulnerabilities, and that it hinders technology modernization efforts. Restrictive licensing practices also lead to what's become known as vendor lock, in which purchasers of software are effectively barred from switching between technology service providers as circumstances necessitate. So prior to 2019, the prevailing industry practice was known as BYOL, or bring your own license. And under that policy, customers who purchased software licenses were free to deploy that software in whatever cloud or server environment sort of best worked for them. And it was a good policy. It encouraged greater interoperability. It encouraged vendor diversification, which is in turn beneficial to cybersecurity. However, in 2019, one of the larger legacy software providers instituted a change to its licensing terms, importantly, out of no particular technical necessity, restricting where its own software could be run. And the change has significantly hindered customers' abilities to use on-premise licenses and dedicated cloud hosting services from small cloud providers to larger cloud providers like Amazon, Google, and others without purchasing additional mobility rights sort of essentially forcing the users to utilize their own cloud services. So the issue has generated quite a bit of concern, I think, at the federal level. In November of 24, the Federal Trade Commission announced it was launching a broad investigation into legacy software providers' licensing practices in their cloud businesses. In December of 2024, the House of Representatives passed a bipartisan bill called the Samosa Act, requiring each federal agency to look at their software licenses and make sure that they're not spending wildly where those licenses should be portable. Several other sort of important points. The Department of Defense is also looking at its overspend on software licenses.
Your time has elapsed, so if you could please summarize.
Sure. So I'll just say this bill has passed in 5 other states, so Missouri, Colorado, New Hampshire, Illinois, and Indiana. And it's currently being considered by another half a dozen to 10 states, and has a support from a number of different coalitions, including my own, as well as NetChoice, the Computer Communications Industry Association, and the Alliance for Digital Innovation. And that's it. I'm happy to take any questions.
Thank you. Are there questions from members of the committee? Representative Blumenthal.
Thank you, Madam Chair, and thank you, Mr. Drexel, for your time and your testimony so far. Did you have the opportunity to review the Department of Administrative Services written testimony?
Yes, I did. And luckily I had a chance to connect with Commissioner Gilman earlier. So I think we actually have a 1 or 2 word fix that will address their concerns, but we're happy to work with them to make sure we're not overly prescriptive about every last word, but I think we can get to ground on that with her in their office.
That was my only question. Thank you very much.
Senator Honig.
Thank you, Madam Chair. Oh, there's my camera. And thank you, Mr. Drexel, for being here. Just wondering, do you have any kind of feedback on the experiences of the states that have passed this legislation?
Mostly anecdotal at this point. New Hampshire in particular, I know Central IT cited a couple different examples in contract renegotiations where they were able to use the recently passed legislation there, to their advantage in ensuring that they had a little bit more choice. Most of these contracts are, they can be for upwards of 5 years. So it probably, the first one of these bills passed in 2022. So we're still a little bit early into the implementation cycle, but at least sort of initial feedback we've gotten from central IT offices has been that it's been a net benefit to have this in their toolbox.
Thank you very much.
Thank you, sir.
That's it, Madam Chair. Thank you.
Thank you, Senator. I just have a few questions. The legislation you referenced in 2022, what state was that in?
Colorado was the first state to have passed it.
And what are the other states that have passed similar legislation?
I think in this order: Colorado, followed by Missouri, followed by the state of Illinois, Indiana, New Hampshire is the most recent state to have passed it, but the bill's currently being heard in Rhode Island, Massachusetts, Arizona, and I by the end of this year, it'll probably be up to about a dozen, 10 to 12.
And is that all primarily at the advocacy of your organization?
Yes, ma'am.
And who are the members of your coalition?
So the 2 large public members are Google and Amazon. Most of the other members are non-public. All of these companies there's about 20 different members, but these companies do business with the large legacy providers, and there's.
Can I interrupt you for one
Please.
second? Can you define a legacy provider?
Yeah, they're larger software providers that also run cloud businesses. So they're both selling software and operating a cloud business. So there are a number of larger companies that I think are more notable for having used this type of restrictive licensing practice. Microsoft is one. Certainly, it's not just them. SAP, Oracle. I could probably name a handful of others, but those are the primary entities we're talking about there.
Thank you. Sorry for the interruption.
No, and just to finish that thought, there's quite a bit of concern around retaliation. retaliatory audits for, I mean, because these are, if you look at productivity software just from Microsoft in particular, the market share is like north of 90%. So businesses rely on their suite of Office products as their primary productivity software. And there's an incredible degree of concern that any attempt to speak out against it not only violates NDAs within the contracts that they have for the purchase of their software licenses, but will immediately trigger audits and sort of predatory practices that make it more difficult to do business in the future with them.
Yeah, what do you mean by an audit? Like who would conduct the audit? You're talking about someone, an entity that has a license with one of these providers.
So the provider itself will launch an audit to review all of the licenses that the customer has purchased to make sure they're in compliance and identify anywhere where they might have expired licenses, or they might have too many users using one set of licenses in it, and then triggers all kinds of penalties and things like that. But those audits are used as kind of leverage to make sure the purchaser of the software kind of stays in line. It's important to note also that this doesn't apply. This is a narrowly tailored law. This doesn't apply to business communications. This is just, or interaction. This is only putting a tool in the hands of central IT offices and public agencies to ensure that when they're using taxpayer dollars to buy the software products they need, they're not being shoehorned into additional services and goods above and beyond whatever RFP might have called for, that they have the freedom and flexibility to say, we need this piece of software and we want to have a competitive bid process where we can look at Microsoft's cloud product, Google's cloud product, Amazon's cloud product, any number of other smaller cloud providers, and choose the one that best meets our needs, that's most cost effective. All this bill does is pull back any restrictions that would remove that sort of agency from the central IT or purchaser in public entities.
So the scenario you laid out a minute ago, though, where audits are used as sort of a penalty for questioning any aspect of the existing contract, wouldn't that, especially if you're only talking about public entities, isn't there a disincentive for the software provider to engage in that kind of behavior if they want a contract to be signed in the future?
Well, part of the problem is these for the cloud providers, or for the cloud services, these those services are often not competitively bid. So about 25 to 30% of, in particular, Oracle and Microsoft cloud services are won through non-competitive bid processes. So there's a particularly stark example in the city of Denver where they came under a pretty heavy audit from Oracle. And I think there was some $5 to $7 million worth of penalties as a result of the audit, which actually sort of precipitated the passage of this bill there back in 2022. So it is, and then I think the other half of that, the knowledge that the customer is so widely reliant on these dominant products is sort of the other piece of it. So yes, you would think that's not really a great way to treat your customers and that they might go find something else. But when you have 95% market share of a particular product, you might lean a little more heavily on that. And I think, we had these conversations in the late 90s about taking your popular products and tying them to non-popular products and sort of jamming them down the throat of your customer. And, that's something that I think lends credence to why, especially at the federal level, there's been a bit more attention on it because it's anti-competitive in nature.
Thank you.
Thank you.
Representative Osborne.
Thank you, Madam Chair. So I don't purport to understand a bunch of this, but from what I'm kind of gathering, so as governmental agencies and municipal agencies are looking at their software programs, at their cloud programs, and as they're looking forward to how they're going to start integrating AI into these packages, this is really prospective on that issue, isn't it? So that Microsoft can't require ChatGPT or can't require Copilot as part of the package so that Gemini and other AI products that are not Microsoft based won't be at a disadvantage. Is that a fair interpretation of that?
Partly. I mean, I to address the first part of your question, I mean, I think this is really it's a sort of software procurement good housekeeping bill. And I want to be very clear that what it does not prevent is bundling services. So the government as a buyer of goods and services should want to see services bundled and to be able to realize cost savings because of that. And sort of take that in its totality as a sort of pricing mechanism to look at it and say, well, you know, this is the best sort of suite of services for us. But I think where it's simply shoehorned in by no particular technical necessity is where it becomes problematic. So, you know, I think we could have a long conversation about the wisdom of siloing software spend with a single company. But, you know, you buy cloud services and software services and operating systems and cybersecurity for one company, because a cybersecurity vulnerability in one becomes a vulnerability in all of them. But this doesn't even restrict the state from doing that. It's just about having the tail not wag the dog. That once the state or the state agency purchases the software vendor shouldn't be able to dictate to the customer what they do with it. So when you get into things like AI that uses an incredible amount of computing, then it becomes a real question of what is the right cloud setup for that. And if that turns out to be Microsoft, that's okay. That's great. As long as it's Central IT's decision to do that instead of being forced into it artificially.
Thank you very much. Thank you, Madam Chair.
Thank you, Representative. Seeing no further questions. Thank you for your time and your testimony.
Great. Thank you very much. Appreciate your time.
And we have concluded our list of people who have signed up for our public hearing today. So we will adjourn our public hearing. Thank you all very much. Have a nice weekend.